Hi, this is Matt Reynolds, and this is the week 7.1 graded assignment. It's a case study presentation. The case is Franklin versus Gwinnett County Public Schools, and the facts of this case are as follows. Frank versus Gwinnett County Public Schools presents the question whether the implied right of action under the Title IX of the Education Amendments of 1972 supports a claim for monetary damages. The petitioner, Christine Franklin, was a high school student at North Gwinnett County High School in Gwinnett County, Georgia from September of 1985 to August of 1989. The respondent, Gwinnett County School District, operates the high school and receives federal funds. Well, arguments on both sides of this case. So on December 29th of 1988, the United States District Court for the Northern District of Georgia, a complaint was filed stating Christine Franklin was subjected to continual sexual harassment beginning in the fall of her 10th grade year, which is 1986, from Andrew Hill, a sports coach and teacher employed by the district. It is further alleged in the complaint that though teachers and administrators knew about the investigated Hill's sexual harassment of Franklin, no action was taken, and Franklin was discouraged from pressing charges against Hill. On April 14th of 1988, Hill resigned his position on the condition that all matters pending against him would be dropped. At this point, the school district ended the investigation. The district court dismissed the complaint on the ground that Title IX does not authorize an award of damages. The Court of Appeals also affirmed the decision. However, the general rule is that the absence of clear direction to the contrary by Congress, the federal courts have the power to award any appropriate relief in a cause of action brought pursuant to a federal statute. When Title IX was first enacted, the court followed a common law tradition and regarded the denial of a remedy of the exception rather than the rule. Further, cases such as Cannon and Grove City versus Bell show Congress has made no effort to restrict the right of action or limit the remedies available to a complaint in a suit brought under Title IX. Since Title IX placed on the Gwinnett County Schools on the duty not to discriminate on the basis of sex, and when a teacher coach sexually harasses a student because of the student's sex, that teacher or coach discriminates on the basis of sex. Congress didn't intend federal funds to be spent on intentional actions that it sought by the statute to eradicate. Moreover, traditional rule is that a state entity is to pay monetary awards out of the individual's treasury for intentional violations of the federal statute. These remedies, permissible under Title IX, are limited to back pay and prospective relief according to the United States. In most cases, the question of whether monetary damages provide an adequate remedy and, if not, whether equitable relief would be appropriate is asked. However, in this case, the equitable remedies offered by the respondent and the federal government are grossly inadequate. Back pay is worthless to Christine Franklin as she was a high school student when the alleged discrimination occurred. Prospective relief also is not a remedy since the teacher coach is no longer employed by the school district and Christine Franklin no longer attends the school in the Gwinnett school system. The court findings. Through the district court, as well as the Court of Appeals, dismissed the complaint on the grounds that Title IX does not authorize an award of damages. It was concluded that a damages remedy is available for an action brought to enforce Title IX. The judgment of the Court of Appeals was reversed, and the case is remanded for further proceedings. That's from Pittman of 2016. So the implications for the athletic activities administrator are this. So the implications of this case under for the athletic activity director are that under Title IX, all students are to be protected from sexual harassment. The fact that the school district investigated the incidences and ignored the situation is abhorrent. Further, they discouraged the student from filing charges against the predator, which is her right under the law. This case is a lesson to all school employees to take harassment cases of any kind very seriously and to protect students against predators. This came from Case Studies in Sports Law, 2nd edition by Andrew Pittman.